Hi, this is Leisha, and I'll be guiding you through Toby's House Crisis Nursery HIPAA training. HIPAA training is about the Health Insurance Portability and Accountability Act. We'll be focusing in on these learning objectives. We want you to be able to review the history and purpose of HIPAA, examine the 3 rules of HIPAA, identify what is protected information, discuss the differences between violations and consequences, and apply privacy concepts in role play. Let's start with what HIPAA is. It was an act passed in Congress in 1996 to technically improve the portability in health insurance coverage when people were between jobs. It's supposed to increase accountability of health insurance companies, promote the use of medical savings account, cover employees with pre-existing medical conditions, and simplify the administration of health insurance. When we look back at the times in which HIPAA was enacted, it was just starting to become a time where people had home computers, where internet and electronic access was more available, where things like MySpace and insurance companies were also connecting via the internet. In 2003, they started to adjust HIPAA to cover some of the things that they needed in the time of computerization. So they started to define what protected health information is, and in 2005 focused on electronically stored PHI. PHI, again, stands for Protected Health Information and is a common abbreviation that we all need to be aware of. You may be wondering why Toby's House has to follow HIPAA guidelines. Toby's House is licensed through the state of Montana as a shelter care or a youth care facility, YCF, meaning a licensed facility in which substitute care is provided to youth and includes youth foster homes, youth group homes, youth shelter care facilities, therapeutic group homes, and child care agencies. This is covered in the Montana Code annotated. We are at Toby's House required to maintain case records for each child that we serve, and all records maintained by a youth care facility and all personal information made available to a youth care facility pertaining to an individual youth must be kept confidential and are not available to any person, agency, or organization except as specified. The data that we collect on children and families that we serve is considered protected data, or PHI. The Health Insurance Portability and Accountability Act has evolved over time to take on the duties of protecting individual privacy and security of health information through 3 basic rules: the privacy rule, the security rule, and the breach notification rule. The first rule, the privacy rule, sets standards for when protected health information, or PHI, can be used and disclosed. It also sets the standards for what is considered protected health information. The second rule, the security rule, specifies that there must be safeguards to protect the confidentiality, integrity, and availability of PHI. The third rule, the breach notification rule, requires entities to notify affected individuals, report breaches to the Department of Health and Human Services, and on some occasions to the media. At Toby's House, we should always keep in mind that while we are taking care of clients, which are children, that the data that we collect from a parent, guardian, or entity bringing this child is also considered protected data. So let's look at HIPAA's list of what is protected information. They have identified 18 items that are clearly protected. These include name, address, age, basically all elements except for their year of age to an individual. So birth date, admission date, discharge date are all considered protected. Social security numbers, medical record or case numbers, telephone number, photographic images, finger or voice prints, any unique characteristic that could identify the individual. That may be a tattoo, it may be a physical characteristic, or other. Other data that is protected that we may not see as often at Toby's House, but still is clearly protected data, is the health plan beneficiary number, an account number, a certificate or license number, a vehicle identifier like a license plate, a fax number, email address, a web URL, device identifiers and serial numbers, Internet Protocol addresses, so IP addresses. All of these are considered protected. The first 9 are the ones that you will be working with the most with our children at Toby's house. So I'm sure at this point you're like, great, I only have to remember 18 things, and only 9 of them are things that we use fairly frequently. Is there any other way to violate HIPAA that is not listed in those 18 qualifiers? Yes. Montana is a small town. Any feature or part of a story that may be in media or happen to be a family neighbor or a friend may be identifiable. For example, a client comes in and overhears a conversation about how the last admission was brought in because their house burned down. The person overhearing can certainly find out who this was via news, social media, or around the water cooler at work. They now know who has used the service and what we should be considering as protected information as much as feasible. Like the candle shown here for a small town, it smells like everything is relative. This is certainly true in Montana. Even in casual conversation, any details of a situation, family, or client at Toby's house can identify them. One of the most common means of violating HIPAA in care settings is just being overheard while sharing information for legitimate needs with a coworker. So now you may be wondering, well, when can I share information? Like Dory here, this can be used as mnemonic, Dory, D-O-R-I, in direct care. Those who are involved in direct care of children and those supervising those providing the care have a need to know. Operational. So if someone has normal internal business activities such as quality improvement, training, auditing, grievance resolution, those types of things, then information is shareable. From the reimbursement side, which may be from the insurance or may be from the state, that is a legitimate reason to share information. And then for individuals or agencies such as a parent or guardian should have access to their child's information or PHI on the file. If there is a signed release on file, perhaps they know that someone else is going to be coming to pick up their child or maybe calling to check in on them. As long as there is a signed release, we can identify the person we are speaking to, that we can share information. Other situations, individuals and agencies that we should be able to share information with would be law enforcement, child protective services or agencies, and emergency responders. So when considering about sharing information, remember Dory. If it doesn't fit into direct care, operations, reimbursement, or the individuals and agencies listed, then it isn't something you can share. If you have questions, please reach out to your supervisor or to the executive director for advice on the situation. At Toby's house, we take the security rule very seriously. How do we work to protect information? We'll have safeguards and security measures to protect the security of PHI and ePHI. We want to protect the integrity and the availability of ePHI for authorized use, identify and protect against threats to security or integrity of data, protect against unlawful uses or disclosures, and ensure that we have good compliance within our workforce. Our policies and procedures will reflect both federal and state laws requiring security of protecting information. It will also include steps that we believe will help protect data. If at any time you think that there's a potential for a breach of data or information that could be disclosed without us being aware, please let your supervisor or the executive director know immediately. Here are some ways that we can all help protect information. Make sure that when you're giving report or you're sharing information about a child or a family, that no one is around that shouldn't be hearing that information. Please ensure that all paperwork that has PHI on it is secured whenever it is not in our direct use. Please utilize your password protection on any files that you are accessing. Please remember that every time you walk away from a computer that you sign out. And then for everyone's protection, we want to make sure that we're using apps and programs and sharing that has end-to-end encryption. Let's talk about the breach notification rule. When something is shared that shouldn't be, what do we do? Well, the breach notification rule requires that Toby's house reports security or privacy of PHI anytime that it has been breached. Our report will have to include the nature and the extent of the PHI revealed, the unauthorized person or party that attained inappropriate access to PHI, whether the PHI was acquired or reviewed or is irretrievable, and the extent to which the PHI has been mitigated. If you see something or hear something, say something.
Let's talk about the different categories or types of breaches. There's unaware, which may be in the form of a database breach or a theft despite security measures, and we may not know whose PHI has been shared and who may be affected or what components of it. There's inadvertent, which may be an accidental, not reasonably predictable type of situation where perhaps someone overheard something and it wasn't a preventable situation. That would come in under inadvertent breaches. Then there's intentional. This is when someone knows the rules, is aware of HIPAA, is aware of PHI, and then intentionally has situations where they are not following the policies or procedures around PHI. This intentional type of breach may be gossiping or sharing personal health information with either a coworker who's not on shift or with a family member or out in the public. Could include improper disposal of PHI, meaning that any form that's being discarded that has PHI on it should be shredded. It may be that someone is not ensuring that there's a release of information signed when that's appropriate. It may be sharing specifics or photos on social media without consent, and not using passwords or secured encryption on electronics. We can avoid intentional categories of breaches just by being cognizant and aware of who's around us, ensuring that documents are shredded when they're no longer in use or needing to be stored, making sure that anytime that we have a photo or a story going out, that there is a signed release of information that gives us consent for that, including for photos. And then just making sure that we're not sharing anything that is secured. So, if someone comes to work and doesn't have a password or it's not working, we don't want someone else to share their password with them. There's the fourth or most serious type of breach called malicious, meaning with malintent. This would be stealing information or an identity or any sort of information that they use for personal use. It could be spreading rumors to harm someone or someone's image, giving out secured passwords or sharing files, especially with anyone who's not working in or with Toby's house. Looking into someone else's personal information when not necessary and when not involved in their care, or sharing documents with those outside of the entity like the press. So as you can see here, there's 4 tiers based on those 4 different types of breaches or classifications. So the first one, just really, it can be unaware of the violation, not having known, taken the correct steps to prevent it, and then something happens anyways. It's still a violation. There's still a fine. It can cost anywhere from 100 to 50,000, depending on how many people and what is involved in that. Tier 2, where someone does something but it's inadvertent, the entity knew about it or should have known about it through violation, while performing their regular duties, between $1,000 and $50,000 per violation. And then there's the purposeful neglect of HIPAA rules, so not following policy and procedures. And a correction has to be made again in 30 days of discovery, and that can be anywhere from $10,000 to $50,000 per violation. And tier 4, willful neglect, and this would be your malintent, right, of HIPAA rules, no effort to resolve the issue after 30 days of discovery, and not taking steps to prevent it from happening again. And while these fines and of the 4 tiers are typically guided towards entities such as Toby's House, who's a nonprofit, that sort of payment could be a devastating one for an error from an employee. But you may also be wondering, well, am I personally responsible? Can an individual be fined? Could I be in trouble personally? Absolutely, yes. It doesn't always happen, but there have been cases where employees who have violated PHI policy and procedure and have come known, they can face criminal, civil liability. If they're knowingly using or obtaining individually identifiable health information or disclosure to another individual or party, they're going to face some of those criminal and civil liabilities. They could face fine, prison, both, or restitution to the injured party. To avoid those types of situations, we here at Toby's House are committed. We commit to protect the confidential information provided to us, to shred documents with PHI if needing disposal, to protect forms, files, and electronic records where unauthorized persons may access them, to speak up if noticing a potential way privacy could be breached, to locking files or keeping them in sight when in use, to logging out when we walk away from a computer, to monitor our own discussions at the nursery, in the public, on social media, and at home to ensure that we are trustworthy, and to notify the director if there's any question of what is shareable. Let's take a moment to think about some ways that we can stop HIPAA violations. We can oftentimes be in slightly uncomfortable situations where someone is posing a direct question that we can't answer. It's okay as an employee at Toby's House to say, "I'm sorry, that isn't information I can share with you." There's another key thing that we can do, which is anyone around wearing their purple shoes? This is a key sentence that we can utilize to just bring attention to the fact that someone's sharing information, and are we sure that there's someone around, not someone around who should be overhearing it? So, in other words, are there parents, are there clients, are there vendors around? Should we, pause for a moment and recognize the hippo in the room that we should be avoiding any conversation? And again, that key little phrase is just, is anyone wearing their purple shoes? Then we all know to be kind of doing an environment scan or check to make sure that we're not violating HIPAA. Also, perfectly fine for you to answer someone's questions with the words, "I really don't know." I can give you the name or the phone number of our director or of my supervisor, and possibly they can provide you with information that I don't have access to. You can also utilize something that is just as simple and polite as, "Oh, you are so thoughtful. Thank you for your concern." And that doesn't mean that you have to answer their question. As we wrap up with this video, we'd like to get everybody into some groups to do some play acting and maybe just kind of experience some situations and practicing how to respond in a way that reflects the values that we have at Toby's House. You will be given a 10-question quiz that may be something that we will give you a link to, and or a code number on Kahoot to complete. It is important that you type in as a username, that you type in both your first and your last name so that we can coordinate your results into your paperwork to have on file for our state audits of our license. Just want to take a little bit of a moment here to thank you for participating and for listening, for being an active, engaged employee at Toby's House, and in helping us to protect information in a way that protects Toby's House and protects you and protects our clients. Thank you very much. Have a great day.